My name is Jon Braaten. I've been a practicing lawyer in Lancaster County for over 10 years. A good portion of my practice has been in juvenile court in both Lancaster County and a variety of other counties in the southeast Nebraska area. The presentation today is a practitioner's primer to give new guardian ad litems and new attorneys or new attorneys in the area an idea and overview regarding the juvenile court process, specific statutes that are important, and different things that go on traditionally in juvenile court cases. The guardian ad litems would generally not be involved during the investigation process, but investigations occur by law enforcement based on reports to law enforcement or reports to Health and Human Services. Law enforcement will then investigate those issues, and if law enforcement decides to remove the child from the parent's home, law enforcement must follow certain procedures. The law enforcement must deliver paperwork to the county attorney, and the county attorney must make a report to the court within certain time frames. Once a child is taken from a parent and temporary custody is placed outside of the parent's home, law enforcement must make a report to the county attorney within 24 hours of taking that child into temporary custody. The court is then required to make a temporary custody order within 48 hours. If a temporary custody order is not put into place within 48 hours by the court, the temporary custody by the department ends and the child must be returned to the parent or guardian. If the court does enter a temporary custody order, one of the first people that will be appointed in the matter is the guardian ad litem for the child. In some counties, parents' attorneys will also be appointed prior to a request for appointment of counsel. In other areas, courts will require that the parents come into court and fill out financial affidavits before they can be appointed counsel. There are certain requirements that the court must follow when entering a temporary custody order, and the statutes are fairly clear as to what the courts must do. But the courts must make a determination that continuing the child in his or her home would be contrary to the health, safety, and welfare of the child, and that reasonable efforts were made to reunify the child with the family. The guardian ad litem will be appointed prior to the actual temporary custody hearing. The guardian ad litem will have an opportunity to try to talk with the county attorney's office to get as much information as possible about the facts that brought you to the juvenile court case. You should also have access to the temporary custody affidavit that will usually be drafted by a law enforcement or by Health and Human Services, so that you can determine what the specific facts were that had the child removed from the parent's home. If the child is removed from the parent's home, prior to the temporary custody hearing, there should be a pre-hearing conference, which is now set forth by statute. Pre-hearing conferences occur prior to any court hearing, and it is an opportunity for the parties, which includes the family members and other parties, to be involved in a facilitated process to discuss the issues that have brought you to juvenile court in a problem-solving atmosphere to determine what's in the child's best interest. As a guardian ad litem prior to going to the pre-hearing conference, you should have conversation with the child if you can. If you do not have that opportunity, you will have to work to what you believe is in the child's best interest while you're at that pre-hearing conference. Pre-hearing conferences are meant to be a non-threatening environment, which is not just information gathering, so that the parties can attempt to get the family back together or get services in place. There are various people that should be at the pre-hearing conference. The parents should be there. Any extended family that has been involved with the family should be there. The county attorney and guardian ad litem will also be there. Parents, if they have their attorneys already, will also be there. Health and Human Services, any service coordinators, school personnel, therapists, if there's previously therapist involvement. Those are all type of people that should be at these pre-hearing conferences. All of these people know a lot about the family, much more than the lawyers do or the guardian ad litems do before you enter the pre-hearing conference, and their input will be invaluable in an attempt to try to have a facilitated process that can reach the goals of the children. As I said earlier, the pre-hearing conference is not just information gathering. If it was simply getting names, dates of birth, parentage, we wouldn't need to have a pre-hearing conference. The pre-hearing conference is designed to get information as to what the parents will need to do to get the children back in their home, what all the other parties will be responsible for, and how to move this case forward at its early stage. You do need to have some basic information. You'll want to find out, are there any current custody orders? Are there any protection orders? Are there any orders in place that do anything with respect to the custody of the children? You'll also want to find out information regarding where the children have been living, whether or not the Indian Child Welfare Act applies. You also need to try to find out whether or not there is any restrictions through any potential criminal cases that would prohibit parents from having contact with the other parent or parents from having contact with their children. The issues that you will discuss that are going to be important throughout the duration of the case are parenting schedules, safety plans, are there any relative placements available, do the parents need to participate in any evaluations, do the children need to have any evaluations, are there any medical needs that need to be addressed with respect to the children. You do need to have a really valid conversation as to are there any barriers to returning the children back to the home. You also will want to set forth some very specific answers as to who is going to pay for the services, when are the services going to occur, how the parents or children are going to get to the treatment providers, whether or not there's any financial considerations or concerns, if the visitations are going to occur over the dinner time or lunchtime, whether or not the parents have the financial resources to provide for the minor children's needs during the meal times. These are all things that you do not want to just have a cursory conversation about during these meetings. You want to have a clear idea as to everybody's responsibilities when you leave the pre-hearing conference, what your clients are going to do or what your clients are going to do if you're the guardian ad litem. You'll also want to, as a guardian ad litem, find out whether or not there's anything that the children need. Do they have any special items at the parents' house that they want to have with them? Are there any special blankets or teddy bears or anything that they need for school? You'll also want to discuss things like their friends of the children and whether or not they're used to going to their friend's house on Friday night and they want to continue to do the same thing, because just because the children are removed from the parents' house doesn't mean that the children can't have the same things that they had in the past. Some of you may also be appointed by the courts as parents' attorneys in these cases, and your role is somewhat similar to the role of the guardian ad litem. You'll need to find out information ahead of time. You'll want to talk with the person that you're representing ahead of time so that the conference can be as effective as possible given the time constraints that you will have. The actual temporary custody hearing will occur shortly after the pre-hearing conference. You will either have an agreement that temporary custody will remain with the Department of Health and Human Services with certain services in place that are designed towards making reasonable efforts at reunification, or you will not have an agreement. As a guardian ad litem, you need to take a position as to what you believe is in the child's best interest, whether that be remain outside of the parent's home or return to the parent's home or placed in other relative placement or things like that. The court will then make an order regarding either the stipulation or a contested hearing that continued detention or placement outside of the parent's home is in the child's best interest, or in other words, placement in the child's parent's home would be contrary to the health, safety, and welfare of the child. The court must also enter specific orders regarding reasonable efforts at the early stage in this case. And so if your child that you're a guardian ad litem for needs services, you want to make sure that the court is entering those orders regarding services so that everybody is clear as to what services there would be. The child may need to go to early childhood development. The child maybe hasn't seen a dentist in a long time or a doctor in a long time. You want to make sure that the Department of Health and Human Services or a contract provider is bringing those children to the doctor, seeing whether or not they need eyeglasses, seeing whether or not they have dental needs, and making determinations regarding the child's best interest. You also want to confirm, unless it is unrealistic to do so, that the minor child will remain in the same school that the child was at prior to the removal. If there is not foster placement available in the general area of the child's home, or even in the city of the child's home, you may need to have court approval for that child to be in a different school. But by and large, you should try to keep the child in the same school with the same routine that the child had prior to the removal. When you leave the court hearing at the temporary custody, again, you want to have specific court orders in place so that you know what's going to happen prior to the next court date. If the child is going to be returned to the parent, you're going to want to know what the safety plan is in place so that we can prevent any future harm to the child. If the child is not going to remain in the home, you're also going to want to have specific orders in place regarding parenting time and anything else that the child will need, whether that be transportation issues to school, transportation to get to the parent's house, transportation to see siblings, or any other needs that the child will have prior to the adjudication hearing. If there is any therapeutic requirements for the child, if they need to have any pre-treatment assessments or mental status exams, the child may have been seeing a therapist in the past. You'll want to find out whether or not that same therapist can be paid for and provided by Health and Human Services so that there's no change in the therapeutic services. If the child has medication needs, you need to know what medication the child is on, whether the child has their medication, whether they need refills on their medication. So you need to stand in the role of the parent and determine what's in the child's best interest as you're sitting at the pre-hearing conference and the temporary custody hearing, so that that child's life, which has been substantially disrupted at this point, can remain as normal as possible with the least amount of changes as possible.
When you're at a temporary custody hearing, as a parent's attorney, you should be very cautious as to whether or not you have your client testify. The parent would be subjected to cross-examination from both the county attorney and the guardian ad litem, and potentially could also be asked questions from the court. As a guardian ad litem, if the parent does testify during a temporary custody hearing, you should feel free to ask them any questions that you believe are relevant as it relates to the petition or the temporary custody affidavit. In the past, I have looked through the temporary custody affidavits in cases such as dirty house cases and specifically asked the parent questions as it relates to the condition of the house at the time that the law enforcement or CPS officials were at the house. When the parent is testifying, you can have them testify as to whether or not the condition of the home is the same as it appears in the temporary custody affidavit, if there are any pictures as to whether or not the pictures accurately describe what the house looked like when law enforcement was at the house. If a parent does testify at a temporary custody hearing, this can be a very easy way for the guardian ad litem or the prosecutor to be able to short-circuit a long contested formal hearing, in the sense that the parent may make admissions that essentially eliminate the parent's ability to contest the petition at a formal hearing. As a guardian ad litem, if you believe it is in the child's best interest to be involved in the juvenile court process and the parent does testify, you need to ask as many questions as you can, because you may not be able to ask those questions during a formal hearing. The next phase after a temporary custody hearing would be the adjudication hearing.
The next court hearing will be an adjudication court hearing, and that's the court hearing in which the court will read the parents the charges in the petition. The court will tell the parents the rights that they have and the possible dispositions that will happen in the court case. The parents will be asked if they understand their rights to a lawyer, their rights to remain silent should their answer incriminate themselves, etc. And then the court will ask if they understand the possible things that can happen. The children can remain out of the home. The children can be placed back in the home. If the children are remaining out of the home for a certain period of time, that in and of itself could be grounds to file a termination of parental rights. So you'll need to listen as a guardian ad litem to make sure that the parents are answering these questions, make sure that they're not nodding their heads and things like that, because we need to have a record of their understanding of the adjudication process. As a guardian ad litem, you need to be aware of the standard of proof at these type of hearings, and at an adjudication hearing, the standard of proof is a preponderance of the evidence. That is a civil standard of proof. It is not a criminal standard of proof, and so you need to be aware, so that you can represent the child's best interest, what the prosecutor must prove to get to the adjudication.
If the court does continue temporary custody of the minor children with the Department of Health and Human Services, and the child remains outside of the parent's home, as a parent's attorney, you will want to consider whether or not there is sufficient evidence that would likely lead to the court taking jurisdiction after a formal hearing. If there is enough evidence, which is most likely the case since temporary custody remains with the Health and Human Services, as a parent's attorney, you will want to consider whether or not the parents would voluntarily cooperate with whatever services would likely be court-ordered in an effort to get the case to move along as fast as possible. That may include things like pre-treatment assessments, drug and alcohol evaluations, parenting educations, etc. Those type of things are going to be ordered by the court, and if your client can do those things voluntarily prior to a formal hearing, that may substantially lessen the time that the children are outside of the parent's home. As a guardian ad litem in these cases, you're also going to want to make sure that the parents are given enough services so that they can correct the problems that brought us into juvenile court, because ultimately it's generally in the children's best interest to be placed with those parents that can be safe, stable providers for the minor children. When you leave these court hearings and any other court hearings, you want to make sure that you have a clear understanding as to what is going to happen after the court hearing. You want to know what services your client will participate in, whether it be a parent's attorney or guardian ad litem. You want to make sure you understand who's going to be doing the referrals, who is going to be paying for the services, when the services will be arranged, how the person, whether it be the child or the parent, is going to be transported to the services, whether the releases will be signed by the parents, so that everybody can have a clear understanding as to the roles and responsibilities after the court hearing. It's one thing to talk about all these things within the court hearing or after the court hearing, but it's another thing to make sure that we know what's going to happen, we know who is going to deal with certain aspects, and who's going to be required to do the things, so that the next time you come to court, you can have all those things in place and substantially reduce the time that the court case may last. The next court hearings would be disposition and review hearings.
If the parents enter a denial to the adjudication, it will likely be set for a docket call and a trial date or a formal hearing date. Most of these cases result in pleas being entered by the parents rather than going to trial. If it goes to a trial, then the court will make a determination whether or not the prosecutor has presented proof by a preponderance of the evidence that the allegations in the petition are true. And if the court makes that finding, or the parents previously admitted or pled no contest, the next hearing will be a disposition hearing. This is really one of the most important hearings for both the parents and the children in these cases, because it sets forth everything that needs to happen early on from everybody's perspective to try to get this case moving forward. After the disposition hearing, there'll be review hearings that occur not less than every 6 months, once every 6 months. You can try to get them earlier, potentially every 90 days or so, if the children are out of the home. It's very difficult if the only thing that you're doing is going to court once every 6 months, because I think it gives the parents a lack of a sense of understanding as to the urgency of getting things accomplished, and it may result in the guardian ad litem not being as involved if they know that the next court hearing is not for 6 months. The strict rules of evidence do not apply at disposition hearings or review hearings. As a guardian ad litem, you do not need to worry about having every single person come to the courtroom that you've talked to As long as you're able to present a report to the court and identify who you talked to, you should not need to subpoena every witness. You should not need to have all these people coming to the courtroom every single time you want to have someone's viewpoints known to the court. As an attorney, I routinely will tell new attorneys that everything that happens outside of the courtroom is substantially more important, or at least as important, as to what occurs inside the courtroom. You need to remain in continuous contact as a guardian ad litem with your ward, with the person that you're the guardian ad litem for. Although the statutes may only require you to meet with them once every 6 months, it does a substantial disservice to the children if that's the only time that you have involvement with them is once every 6 months, which presumably is somewhat close in time to when there's a court hearing. You should routinely send emails out to HHS or any service providers. You should routinely send emails out to CASAs or the county attorney or any therapists that are involved in the case. I send out sometimes weekly emails to everybody in the cases when we need to have information on a weekly basis, but at least a monthly email, short email that tells people what is going on at this point, asks questions, gets a brief update from therapy, sees how the kids are doing in school, sees how the visitation is going with the parents, and gives everybody the opportunity to discuss things and talk about things, so that we do not need to wait until the court process to try to do these things. Most of the issues that are present within the cases can be dealt with and resolved prior to court hearings or well in advance of court hearings. There are some issues that you want to talk about routinely at every single court hearing. You want to have a chance to have the children present at the court hearings. If you have court every 6 months, the children are going to grow substantially in that 6-month period. It's important for the court to see the children. It's important for the court to be able to talk with the children. The court can see how much the children have grown. It's also important to see how the children interact with the parents at the court hearing, and just in general how the children are behaving. It's one thing for the court to read about families and read about children in court reports, but it's substantially different when the court sees the children and sees them interacting with other people at the court hearing. You should try to address all of the contested issues with the parties on a routine basis. Sometimes you need to have those issues addressed and dealt with in the court hearing, and you need to have a court make the decision when there is general disagreement about what the answer should be. But if you have good communication prior to court hearings, open and honest communication as a guardian ad litem with the children that you're guardian ad litem for, and with HHS or the service coordinators, those hearings can then be used as methods for the court to be able to ask questions, for the parents to be able to ask questions, and for the children to be able to be present, to be able and talk to the judge, to let the judge know what they're thinking, let the judge know what is going well in their life, and any concerns that they may have. It's difficult as a guardian ad litem to appear at a court hearing and find out new information that you were unaware of. If you as a guardian ad litem or you as a parent's attorney know about things ahead of time, you want to raise those so that the first time people are not hearing it is when they're sitting in the courtroom. If the parent's attorney is not having the parent do what the parent needs to do, or if the guardian ad litem is concerned that Health and Human Services or the service coordinator is not getting services in place, it doesn't do the child any good to send an email and 30 days later or 60 days later or 90 days later complain in court why the email was never responded to. And so you should not wait to use court as the method by which you gain what you need to do for your child, because if you do that, you lose a lot of time and the child is really not benefited from that. It may make you feel satisfied as a lawyer to show somebody didn't do what they were supposed to do, but at the end of the day, that it does not really serve any good to the child. So you need to make sure that those things are dealt with in advance of the court date and not waiting until the court hearing, because if court only occurs every so often, these things need to be addressed outside of the courtroom. One of the primary things that can be utilized as a guardian ad litem in these cases is the attendance and cooperation by parties at team meetings. There should be team meetings in every case at least once a month. You should be getting invitations to those team meetings. You should know when the team meetings are. The parents and the parents' attorney should also be at those meetings. Children's therapist, parents' therapist, school personnel, anyone else that is important to the team that has information about the child and the parent should be present at those team meetings. If you have children at the team meetings, you can have portions of the team meetings that talk about things that the children should hear. And you should also have time in which the children can be removed from the team meeting so that the adults can have adult conversations about what's going on in the case. At these team meetings, it is clearly in the child's best interest that an open, honest dialogue occur as to the process that you're in, the progress that the case has made, and the deficiencies that are occurring in the case. You want to ask questions as guardian ad litem. You want to find out whether or not the parents are making the visitations. You want to know whether or not the parents are going to the therapy sessions. You need to know if there's a barrier to the children returning home, how to try to put things in place to get that barrier removed, because that generally is in the children's best interest. You'll also want to update about school, about the children's therapy, about social activities the children are doing, any sporting events that the children have, doctor's appointments, and those type of things. You need to sit in the role of the parent and think as to what a parent would ask about so that you can address those issues at these monthly team meetings. If you miss a team meeting, make sure you contact HHS or the service coordinators so that you can find out when the next team meeting is. Routinely, if you miss one, they'll schedule it at that prior team meeting and you may not ever get an invitation. So it's up to you to keep calling people to find out when the next meetings are. Again, team meetings must address current progress, concerns, services, goals and needs of the parents and children. It doesn't do anybody any good to have lengthy team meetings that don't address the things that need to be addressed. Sometimes it's difficult for people to have bad information given to them or to be told things that may hurt their feelings a little bit, but we have to do those things in order to move this case forward. At about the 12-month period after the children have been removed, if they've remained outside of the parent's home, there will be a permanency hearing. Each child in foster care under the supervision of the state will have a permanency hearing by the court no later than 12 months after the date the child enters foster care. You also will have one of these hearings annually after that. You may not get to a hearing at 24 months or 36 months, but there's a requirement by statute that those occur. The court must make specific findings at the permanency hearing regarding the appropriateness of the permanency plan that's determined for the child and whether or not, if applicable, the child will be returned to the parent, referred to the state for filing of a termination of parental rights, placed for adoption, or referred for guardianship. The permanency hearing at 12 months means that the children have been outside the parent's home for at least that long of time. They're a very important hearing. They should be taken very seriously. You should not just submit a piece of paper that says, here's what the permanency plan is, and everybody finish the hearing in a short amount of time. These hearings need to address all the progress that's occurred in the last 12 months, any of the deficiencies that have occurred in the last 12 months, because at this point the child's been out of the parent's house for a long, long time, and we need to start making progress towards permanency. If there is a case in which there is a compelling reason that would indicate that it is not in the child's best interest to be returned to the parent's home, there should be a referral for a termination of parental rights. The court should make a permanency finding for adoption with a fit and willing relative or placed in a guardianship. Again, this hearing must be meaningful. Sometimes these hearings are brought at the same time as a disposition review hearing. Sometimes these hearings are not given much attention as opposed to a regular review hearing. These hearings have substantially different goals and functions than a review hearing. And so you must be aware of what the statutes are. You must be aware of what the court's requirements are so that you can have a permanency hearing that is not just a lengthier review hearing. There should potentially be a separate court report prepared by Health and Human Services or the service provider, which is specifically geared towards what permanency is and what the permanency goals are. At this point, there are potentially only a few months before the child's been out of the home for 15 out of 22 months. And the parents need to have the understanding that that is not necessarily a long ways down the road when they're sitting at these hearings. If you have a child in a juvenile court case that's of sufficient age to understand these things, the child may be aware of that as well. If the child is at these permanency hearings, you want to take good caution in whether or not that child should be in the court hearing, during the court process, in hearing these things. So just take into account what the child is hearing when they're sitting in the back of the courtroom as to whether or not you think that that child should remain in the courtroom. If the child does not return to the parent's home within a sufficient amount of time, whether that be 6 months if the child has been abandoned by the parents, or if the parent has substantially or continuously failed to correct the conditions that led to the adjudication, or whether that be that the child was out of the home for 15 out of the most recent 22 months. The county attorney's office or the guardian ad litem may file a termination of parental rights. There are multiple grounds for termination of parental rights within the statutes. The standard of proof at a termination of parental rights is clear and convincing evidence, which is slightly higher than the preponderance of evidence standard that you've been used to for the adjudication process. If the county attorney is not filing a case in a timely manner, the guardian ad litem has a responsibility to make a determination as to whether they believe it's in the child's best interest to reach a permanency decision other than returning the child to the parent's home. If the guardian ad litem believes that it's in the kid's best interest to have a termination of parental rights filed, the guardian ad litem should be filing that termination of parental rights. If the guardian ad litem does file the termination of parental rights, the county attorney will join in that motion or at least assist at the termination of parental rights hearing, so that if the guardian ad litem feels like this may be something that they're not used to or they're not familiar with presenting the case on their own, they should have some assistance by the county attorney's office with respect to those trials. If the court does enter an order terminating parental rights of the minor child, there are potentially three options that could occur. The child could be adopted, the child could have a guardianship put into place, or the child could simply go on to independent living. If there is an adoption that is on the horizon, the court will have a guardian ad litem appointed for purposes of determining whether or not a communication and contact agreement is in the child's best interest. So if you are the guardian ad litem for a child in a case that has had a termination of parental rights and the parent's attorney is asking for a contact agreement, it is up to you to review that contact agreement, and it's up to you to make recommendations or sign off on whether or not you believe that's in the child's best interest. If the adoption is not the option that is decided on in the case, or the child is in a guardianship or independent living is the option, you want to take great caution in cases in which the child ages out of the system. In other words, if the child turns 19 and the parents haven't corrected conditions that led to the adjudication, or the parents have relinquished their parental rights, the child may be lacking a lot of adult support services once they turn 19. As a guardian ad litem, you should have at that point had a lot of contact with potentially other family members. Just because those family members may not have been able to provide long-term placement, they're still family members, and they still may be able to be a good supportive service for these children. You'll also want to take a lot of time and effort to look at long-term goals for the children that have aged out of the system, whether that be formal ward benefits or assisting them with educational issues, helping them learn how to do things like search for jobs or look for apartments. There may be family support workers that assist in those things. There may be caseworkers that assist in those things. But you need to take ownership over these young adults that have now aged out of the system, so that they have things in place for them when they turn 19, so that they have a future, so that these children are not just leaving the system without any hope, without any income, without any education, because those children are ones that are going to have a very difficult time, especially when their parents have not done what they needed to do to get them back in their home. So make sure that you don't just look at their 19th birthday as the date that you close your case. You look at their 19th birthday as the date that you've ended your legal relationship to them, that you've spent a lot of time with them over the years, that you've helped them build some community resources, some family resources, or any other people that can be around these children to help them be successful. Being a child in a juvenile court case, a lot of us probably would never have any really understanding as to what that's like. I can only imagine that it's very difficult, that they were removed from their parents' home, that their lives were a little bit different than their neighbors who were living with their parents through their childhood. And so they need some additional assistance. They need us to care about what happens to them in the long run, and not just end the case when they turn 19, so that you don't ever have to go back to court with them, because that's really just the beginning of their life, and that's the beginning of what they do as an adult. And so the more services we can have in place, and potentially there is some aftercare services that may be able to be put into place for them. So make sure that they know and understand these things. They may not know what it's like to apply for a student loan. They may not know what it's like to need to provide for their own medical care. Those are things that you should be talking with them about, and you should be talking with them well in advance of their 19th birthday, so that these things can be into place to make a smooth transition into adulthood. This has been a very brief overview of the juvenile court process from not only a parent's attorney's perspective, but also the guardian ad litem's perspective as well. What you need to be aware of is that each area is different, each case is different. Although a lot of the cases may seem similar, they may have different needs, they may have different things that need to happen in those cases. You should really take a lot of effort to look at each individual case as an individual case. You need to be aware of what your judges require. You need to be aware of what different areas of the state require, so that you can really understand how to best represent both the children and the parents in these cases.